Hi everyone, if you have immigration questions, si tienen preguntas de inmigración, you can put them in the comments. I will do my best to answer them as long as they are not too specific. I'm live on two platforms today, on TikTok and on YouTube. So I will be looking at a couple different screens here. If there's something in particular that you are interested in, si tienes algo en particular que quieren que hable, me lo ponen en los comentarios. I've been getting a lot of questions lately about DACA and if there's any news regarding Judge Hannon's order. I don't have any news regarding DACA yet, so I'll keep you updated on that as soon as I hear anything. Okay, so nothing about DACA yet. The other questions I'm getting a lot about are two types of parole: advanced parole and military parole in place. One, is advanced parole still an option? The answer is yes, but not emergency advanced parole. We've noticed that we're just getting a lot of denials on emergency advanced parole nationwide, not just us, but attorneys nationwide are just not getting those emergencies granted. And what's interesting is that we heard a comment from a USCIS officer who had said, that if it cures an entry without inspection, they weren't inclined to grant it. And I don't think that that was supposed to be an official comment to us, but it kind of took me back because most advanced paroles are going to cure an entry without inspection. Nonetheless, regular old advanced parole for medical reasons, for family, humanitarian reasons, those are still being processed, but it's taking quite a while, 17 to 18 months. Okay, so a lot of questions about DACA recipients using advanced parole and whether that's still a viable option. Now, the other questions I'm getting a lot about are military parole in place and whether those are still being issued. Again, the answer is yes, but they're taking a long time. And now what's interesting is that we have attorneys reporting that USCIS is denying the work authorization and asking for the additional fees from that were published in July of 2025. So the fees have increased for the work authorization for the military parole in place. So you might get a rejection and a request to pay fees, but those, in theory, both programs are still up and running and nothing has changed substantively for either DACA advanced parole or military parole in place. So I wanted to get that out of the way because I've been getting a lot of comments on my videos asking about DACA news and whether anything has changed, and nothing since the order. Okay, the last order that we got. I expect more guidance coming soon. Thank you for the likes. Thank you, La Pleblita. Good morning, David Anderson. If you have any questions, you can put them in the comments. Si tienen alguna pregunta en particular, me lo pones en los comentarios, ¿vale? Now, hola, Diego. Hi, Diego. So the next thing I want to talk about is a federal district court case, criminal case that was filed last week against a fake immigration firm that was conducting full immigration hearings and issuing fake documents, green cards to people. And I've already made a few videos about this, but your USCIS interview, your green card interview, will always be in person. So if they're telling you you're going to meet with some official via video, something is not right. And that's essentially what was happening. These were people abroad, some in the country, that created a fake law firm. They, of course, never actually appeared in person with the people, and the clients never actually went to USCIS, and their courts were via Zoom as well. Now, that's more common. A lot of EOIR proceedings are being conducted via WebEx, but in most cases, your attorney has to request it, and often it's only the attorney via WebEx. In some cases, the client also, but you'll get pretty specific guidance. It's not universal. And anybody that tells you it is universal is, I would question that. Third thing to look out for is WhatsApp communications. If firms are reaching out to you via WhatsApp, I'm not saying we don't use WhatsApp, we do on certain occasions, but if firms are only communicating with you via WhatsApp, that's a big red flag. There should be a website, there should be a local number, and you should be able to call them outside of WhatsApp. So this firm in particular had run thousands of fake cases, fake green card cases, fake naturalization cases, fake asylum cases, and had done all of the communication via WhatsApp. Okay, Tamara is asking me, good morning, would you advise someone submit their application on paper or to send it online? Sometimes you don't have a choice. So it depends what application you're talking about. The I-130 can be done online, but for example, the I-485 needs to be done on paper. So if you are doing an adjustment of status, you're doing a one-step, it doesn't make sense to do the I-130 online and the I-485 on paper. You should just do both on paper and send it together. Now, if you're talking, for example, like an I-589, an asylum application, it depends a little bit what your goal is. There's kind of some anecdotal evidence that asylum applications submitted online are going to get their interview sooner. Okay, that's in our experience for the most part the case, versus the paper submissions are taking a little longer. If you do not have the strongest case, maybe you don't want an interview under this administration. And so maybe then you do submit it on paper versus online. Now, that's not a guarantee, but that's just kind of anecdotally our rule of thumb, and a lot of attorneys can agree that generally the people that are getting really quick interviews after filing the I-589s or the asylum applications have submitted them online versus on paper. Doesn't mean that on paper it will automatically be, a long time until you're scheduled, but it increases your chances. So Tamara, if you want to give me more information about what it is that you are submitting, I can maybe answer your question a little bit more directly, because like I said, some things you are not allowed to submit online. You have to submit on paper. So you don't have a choice. I hope that helps. If anybody else, hello. Hi everyone, it's been a while. Thank you for joining. I know that I used to go live a lot and I haven't for a while. So if you have questions, thank you for the likes. If you have questions, put them in the comments. If you have something in particular that you want me to talk about, si tienen algo que quieren que hable, me lo ponen en los comentarios. Emmanuel, no, that's what I started off with. I'm sorry, if you're talking about the update in the Fifth Circuit decision, which one are you talking about, Emmanuel? Are you talking about DACA, or are you talking about Maldonado Bautista, the bond hearings? Can you give me some context as to which decision in particular you're talking about? If you're talking about bond hearings, there is no change. Yeah, okay. No. So Emmanuel, thank you for your question. I started with this because this is probably the most common question I'm getting is, do we have any news regarding the DACA decision? And the answer is not yet. I promise you, as soon as I get anything, I'll make a video. But No, no, that's okay. I understand you just joined, and it's a really common question I'm getting, but I don't have anything yet. Thank you, Noman. Okay, asylum approved April 2024. I-485 applied October 2025. When is your green card expected? Um, well, remember, Noman, that there are some benefits that are completely paused right now. So you need to I would consult with your attorney to see if your I-485 is going to be affected by any of the pause in adjudications or the review, the fraud review of adjudications with USCIS. Remember that they have paused benefit adjudications for a lot of people, and they're doing a review of the underlying submission. So, for example, if you're getting your green card through asylum, they are not processing those green card applications until they do a review of a lot of the recently approved asylums if your asylum was granted with USCIS. Now, if it was granted by a judge, then it might fall out of that review, but that could be a reason that it would take longer. Okay, Tamara, you want to adjust your husband's status who lives in the United States. So I'm going to assume that you are a US citizen, right? And you want to petition for your husband. In that case, you need to do the I-130, I-485 together. But also he has to have entered with a visa. If he didn't enter with a visa, then you can't do the adjustment. I'm going to assume also that he entered with a visa. In your case, you're going to do everything together. I-130, I-485, I-765, I-864. You're going to submit that entire packet together on paper. That's what we would do given the facts that I just laid out. I would do everything on paper, not half online, half on paper, okay? Jingy, I received my documentary qualified email on March 2025. When will my appointment be soon? So one thing, the biggest dictator of how long it takes to get your appointment is what country you're from, right? So what consulate are we waiting at an appointment for? I just made a video about the Juarez appointments. Okay. And so we got an interview for April based on an approval in March of 2025. Now, this was the spouse of a US citizen. So remember that the categories also matter. Now, this is just a range of times. It's not something that's, like guaranteed that because mine is taking 16 months, yours is going to take 16 months. It's okay. Oh, okay, she got one in 16 months. They got theirs in 20 months. They got theirs in 10 months, right? And so you can take like an average. Now, but in theory, yours should be coming pretty soon in Juarez. You're welcome, Tamara. I hope I'm pronouncing your name correctly over on my YouTube live. So, Jingy, yeah, again, depends on your category, who's petitioning for you. Depends on the consulate, you're at Juarez, and of course the date that you were documentarily qualified. Juarez is going to be one of the longer consulates. So your spouse is a US citizen then, and yeah, you're probably going to be getting your interview relatively soon, which is good news. I've noticed that spouses of US citizens, whether it's an adjustment of status application or whether it's consular processing and they need to do a waiver, an I-601A waiver, are being, for some reason or another, prioritized, which I mean isn't a bad thing, but they are moving faster, despite the fact that a lot of the other processes are taking longer. Okay, tumbleweeds. Are AOS inside of the United States for parents of citizens still being processed for the 75 pause countries. Yes, so they should be. Now, remember Asim, I'm going to kick you out. Remember there are two kind of categories of pauses or bans or reviews. So there's the travel ban, right? If you're from one of those listed countries on the travel ban, that is going to affect family-based petitions for people who are doing the visas or their interviews outside of the country. That is not going to necessarily affect inside USCIS adjudications, okay? In theory, that's supposed to be applied only to those consular interviews and issuance of new visas abroad. Now, is it very likely that there's going to be a review of people's submissions at USCIS based on, their country of origin? Yes, even though it might not be official. However, there is no reason to believe that you're not going to get an interview and you shouldn't get an approval despite the fact that you're from one of those countries. One second. I got a couple. Are people with a green card safe with a 212H granted by a judge? Rewards loyalty. So, if I understand correctly, it's been granted and now you have a green card. Is that correct? If so, then yes, you're like any other, green card holder. You need to abide by the terms of that, the permanent residency. You don't want to commit any crimes. You don't want to stay out of the country for too long, but if you're a green card holder, you're a green card holder, and kind of the reason or the way in which you became a green card holder at this point isn't relevant until maybe you apply for naturalization, and they are, in their discretion, reviewing, everything, reverse engineering how you got to your naturalization and seeing if there was any, misrepresentation, fraud, errors committed in the prior submissions. Okay, Tamara, you are doing a one-step adjustment of status. And when you submit all the forms, you submit all of the evidence together. At the interview date, you're going to be requested to bring updated documents as well as your original submission. So you're also going to take papers with you to your interview on the adjustment of status. When you submit the one step, you are going to be supplementing all of the forms with the evidence. You're not just doing the forms and then waiting for the interview to bring your supporting evidence. Tumbleweeds, you're from Brazil, it's been 83 days and you haven't had biometrics yet. Nothing about what you're saying to me right now raises a red flag. It depends a little bit what your field office is, where you are. Again, adjustment of status based on marriage to a U.S. citizen. In some field offices, one steps are moving really quickly. We've had approvals in 2 or 3 months, which has been crazy. But that's not the case around the country. It really depends on the field office. And I wouldn't be concerned that, you haven't had your biometrics yet. When you start getting into the 1.5 year range with no movement, then that's when it becomes, a little bit more concerning. Okay, Kaori, they scheduled an interview for my I-130. I have deportation. I'm scared to go. Yeah, I understand. This is the situation of similar to my client who had an I-130 interview at the beginning of February. He didn't have a removal order, but he was placed in removal proceedings prior that had been administratively closed. And then they were reopened. So they were reopened, and then we got a notice of an interview at USCIS for his I-130. And I told him, there's a chance that you get detained at your interview. And he did. He got detained at his interview on his I-130. Now he's out, and I'm so happy for him. But between February 9th and February 26th, we had to file a habeas corpus. I had to file a bond motion. I had to file the approval of the I-130, which happened on the spot with the court, in order to argue bond. So he was detained for 2.5 weeks prior to being able to get him out. And this is somebody who was in removal proceedings, not who had an actual removal order. So, I would, Kaori, I don't know how to pronounce your name. I would definitely consult with your attorney about, the risks of appearing for your I-130 interview with a removal order. And be prepared for anything that could happen, including detention at that interview. And maybe, you decide to take another step, a different route. Maybe you decide to withdraw the I-130 until we have a more favorable administration. I don't know. But definitely consult with your attorney. I'm sure you have. I don't blame you, and I'm not going to lie and say, oh, you shouldn't be worried, when I literally just had a client detained at their USCIS interview, and they didn't have a removal order. They were only in removal proceedings. Like I said, that ended up being okay. Everything is okay. He's out now. He's back with his family, but it's still, really a really unfortunate situation that he was in. Cal Simpson, this administration is making you want to become an attorney so you can help those in need. Is 40 too late? I don't know that I'm the person to give career advice. I don't think 40 is too late, and I don't think I learn new stuff every day. The administration keeps changing the rules, so we're constantly learning. So you wouldn't necessarily be behind, right? We are all adjusting. Attorneys who have 30 years experience are dealing with things that they've never had to deal with before, right? Because of the executive orders, the arbitrary new rules coming out, the lawsuits, the unconstitutional practices that are being challenged, right? And we're truly learning every day. I'm looking up the case. What did that case say? And adjusting. So I don't think it's too late if you have the energy. That's the only thing. It's like having kids too late, right? I wish I would have had them younger, because I would have had more energy. But other than that, I don't necessarily think you'd be behind, because all of us are doing this for the first. A lot of the stuff that we're doing is the first time. Many immigration attorneys have never filed habeas corpus before. That's a federal lawsuit, right? So typically immigration attorneys were dealing with administrative agencies, EOIR, USCIS. They weren't necessarily litigating in the judiciary. And now they're flocking to get admitted in federal court. Nayeli, with an administrative closed case and a pending asylum, do I accrue unlawful presence or no? So you don't accrue unlawful presence. There's a really big red caveat to that. You don't accrue unlawful presence if you've never worked without authorization. Okay, so as long as you only worked with authorization, then you are protected from accruing unlawful presence. The reality is that very few people actually never worked without authorization. And so if you're debating whether or not you should file a waiver of unlawful presence versus not file a waiver of unlawful presence, for example, to do like a consular interview abroad, and you're like, well, I had pending asylum, so I'm not accruing unlawful presence. Unless you with certainty can prove that you never, prove a negative, prove that you never worked unlawfully, I would suggest doing a waiver of unlawful presence, because you don't want to be stuck abroad and then they say, sorry, you accrued unlawful presence because I don't believe that you didn't work without a work authorization. So yeah, yes, that's your case. I do have consular process and your husband is a USC. Right. So I know based on what you've told me, pretty much exactly what you're talking about, right? So you have a pending asylum and an admin closed case. Maybe you have an I-130 that you're waiting for approval or it has been approved, and now you're either deciding to work on the waiver or just go abroad for your consular interview. You're right. You could just go abroad for your consular interview, well, ask to terminate the case and then go abroad for your consular interview and then say, hey, I don't need a waiver of unlawful presence because look, I had this pending asylum. I didn't accrue unlawful presence. I never worked without authorization. And if you're confident in that, you really didn't, and they will believe you, then, consult with your attorney for sure. I don't know the specifics of your case, but if that is the case, in theory, you do not need a waiver of unlawful presence. If there's any doubt as to whether or not you kind of broke that seal and you did work without authorization, then do the waiver of unlawful presence just to be safe. I know it's a longer process, but it's, as attorneys, we're in the process of mitigating risk. And so I would definitely suggest mitigating that risk. Excuse me, I need to finish my coffee. Nobody wants to see that. Okay, so I hope that answers your question. Si me quieren hacer preguntas en español, también pueden, ¿vale? Me hacen preguntas en español y te las respondo en español. You're welcome, Nayeli. Good luck. And, it sounds like you're doing everything the right way. Thank you, Tumbleweeds. I appreciate that. So the other kind of really common scenario that I've been getting a lot of consults about has been the Keelantan entries. A lot of people were unfamiliar with a Keelantan entry. And the Keelantan entry is when people entered, I'm sorry, you're waiting on your I-824. Do you know how long that is taking to be approved? Like the transfer, I don't know, but I can see. Oh my gosh, sorry, my computer is freezing here. Let's see what I can look up. All right, well, I'm not getting, my computer's freezing. But I would say, Nayeli, I generally tell my clients the I-824 can take 1 to 2 years, which is a very long time. And I know that that's very frustrating. In some cases, it's taken so long that we've done a new I-130 and just done like the consular process, like withdrawn it. Or I've had to threaten mandamus in some situations where they haven't taken action on the I-130. They haven't transferred that case over to NVC. It's been a really long time since we made the request. And, we've had to sue or threaten to sue the government to act on that request. Okay? So I was talking about Keelantan entries, specifically in the context of parents of U.S. citizens. I have so many people that I consult with that have consulted with a lot of other attorneys, and no fault of theirs, by the way. I understand why people jump to conclusions, but they don't realize that they might be eligible for adjustment of status because since they didn't enter with a visa, they're just told, oh, you need a waiver of unlawful presence. You can't do that through your US citizen son or daughter. So there's nothing we can do for you unless you're willing to wait outside of the country for, 10 years. And then we get into the weeds. And actually, it turns out they did enter they were inspected, even though they didn't have a visa. Like, they were waved through at the port of entry. Many, many, many people don't realize that you can argue that you were inspected and therefore you're eligible for an adjustment of status. And so specifically, people who entered through the southern border in the 80s and 90s were waved through often in a car. Like, they were passengers in a vehicle, they were passengers in a truck, and they didn't have a visa, but the person that was driving them did. They didn't talk, they didn't commit any fraud, they just sat there in that car, that truck, whatever was waved through. And they were in theory inspected. They went through a port of entry. The immigration officer could have asked questions. They didn't ask questions. So you can argue the equivalent of that being like an entry with a visa, and therefore adjust through your US citizen son or daughter. Now, it won't cure everything. If you have a permanent bar, then that's not going to help, because the permanent bar is permanent. This is only going to help if you have an entry without inspection and you've been told you need a waiver through a family member, but you don't have, right, a qualifying family member. The permanent bar gets to be really confusing for people. So let's review what that is. People think it's just if you have multiple entries. That's not necessarily the case. You can have a gazillion entries prior to April 1997, and 99% of the time they won't count. It won't count against you. After April of 1997 is when we have a new law that comes into effect. If you entered after April 1997 or before April of 1997, but you stayed after April 1997 for a period of 1 year or more, then you left the United States and re-entered without inspection, then you likely have the permanent bar. Oh, Rebecca, your husband is in the same situation? Interview is scheduled March 13th. Oh, okay, Rebecca, you're saying your husband has an I-130 pending and he has a removal order. Guys, hold on. Are you all aware of the Calderon settlement, which is specifically for spouses of US citizens who have removal orders? If you move to New England, Rhode Island, Vermont, New Hampshire, Connecticut, Maine, under the Calderon settlement, ICE has to reopen and terminate those removal orders, and they are protected from removal at least until January of 2027. Anybody who is the spouse of a US citizen right now who has a removal and is thinking of going through this process, whether it's adjustment or consular processing, I would be very hesitant to proceed and go to these interviews with a removal order. There's a high chance of detention, okay? But I would definitely consider taking advantage of the Calderon settlement. If you move to New England, and I know that that's a big if, it's a big ask, but it doesn't need to be permanent. It can be, a move for the next school year. Your spouse, regardless of the reason of the removal order, whether it was in absentia, whether it was they lost asylum, etc., is eligible to have that removal order automatically reopened and dismissed. And they are also protected from removal until January of 2027. When you submit the request for that reopening and dismissal of the removal order, you also need to show your intention after the I-130 is approved. So whether it's consular process, whether it's adjustment of status, you need to show what it is that you're going to do, and you have to have that application not submitted, but prepared to show the government, look, I'm ready to move forward once you get rid of this removal order. And then the I-130 is approved and we have this I-601A waiver ready to go. So again, for those of you with spouses that have removal orders that are US citizens, or for those of you who are the spouse of a US citizen that has a removal order, if you are not familiar with the Calderon settlement, I strongly suggest that you become familiar with it prior to proceeding with these interviews at USCIS, where you have a very strong chance of detention. And if you have more questions about that, please let me know. Perla, hello, my partner got reinstated his deportation. He's detained 6 months. We have habeas, can we get bond? So if he had a removal order reinstated and it's now been 6 months, with I'm a little bit confused. You mean he got his proceedings reinstated, they recalendared them? That's different than having like a removal order reinstated. That removal order, if he has a removal order, he's been detained 6 months, you do habeas, and then you ask for a straight relief because they haven't removed him after 6 months. If you're saying his removal proceedings were recalendared, if you have habeas corpus, ordering a bond hearing, as long as you're not in the Fifth Circuit, Tennessee, Louisiana, Mississippi, then he should be eligible for a bond hearing. I can't tell you if he's eligible for bond because I don't know if he has a criminal history. I don't know what community ties he has, but he should at least be eligible for a bond hearing. Mimi Marbalos, if you have to submit evidence of living in another country, what type of evidence do you send? I am not sure what you're talking about, Mimi. What process are you talking about? You have hundreds of pages. For what type of process? User 722-593, I need to apply for adjustment of status. I have no status and a DUI. Should I wait it out? Depends on when you got that DUI. Depends on the severity of that DUI. So if it's recent, probably wait. If it's more than 5 years old and, it was dismissed, then I would definitely suggest, consulting with an attorney. Make sure you have that dismissal, that disposition available for them. But in theory, that's not a conviction. A dismissal is not a conviction. So you don't have a DUI. You got arrested for a DUI. You got pulled over for a DUI, but you don't have a conviction for a DUI. In other words, you have no criminal record, if that's all, on your history. I would definitely suggest a consult to talk about your facts specifically, because if you're AOS eligible, then yeah, there's no reason not to. You're welcome. Feel free to call us. I'd love to help with that. Our AOSs are getting approved so quickly, depending on the type of AOS it is. But if it's a family, immediate relative based AOS, getting approved super quickly. Perla, he has a deportation in 2004. He got detained in August. No criminal record. He got detained in August. So it has been over 6 months. Yeah. I would file habeas corpus to say, hey, he's now been detained in excess of 6 months. That's the threshold, 6 months after a removal order. If you don't remove him, then yeah, he's entitled to essentially immediate release. Okay. Let's see, I got a R. Any updates on what consular appointments are working in Ciudad Juarez? For R1, for religious workers, I have no updates. I don't know. I don't have anything anecdotal that I can pull on. I'm sorry. But I'll write it down to look into. And I will see if I can. R1 Juarez. I'll look into that. Okay, Mini Marvalos. I-485, they sent an intent to deny. They believe I lived in the US since first son was born in 1997. I see. So, yeah, Mimi, I'm still not fully understanding what your question is. It looks like you got a notice of intent to deny on your I-485 based on something not lining up in your history and where you were living. So if your question is what evidence do you send to prove physical presence, whether it's in your home country or whether it's in the United States, you can send bank statements, you can send rental agreements, mortgages, doctors, medical records, school records, obviously birth certificates of any children you have, your children's medical records, your children's school records, affidavits from friends and family, photos. So there's a lot of things that can, paychecks, right, from your employer. All of that stuff would prove physical presence in either country. Okay, so I hope that that helps. Anyway, so I wanted to go. Oh, Vane, where can I check my husband's habeas corpus status? Are you talking about the actual filing in federal court? Where can you check his, like, what's going on in that case? Whoever the attorney is on that has a case number. There's something called Pacer. You have to create a Pacer account, and you can look up the cases on Pacer. There's also something called habeasdockets.org, where you can search every single habeas petition filed essentially nationwide based on the jurisdiction. You can search by date filed. It'll have the name, unless the attorney has opted out, and then it won't show up there. A lot of them are on habeasdockets.org. So that's where I would start, and also the case number. But I imagine that, any update you get, your attorney gets on the habeas should be forwarded to you. At least when we get the Pacer notifications of an order being entered, a response being filed, we forward that. It's an email that comes in. So, but at the top is a case number. It's going to be like 125 CV something, or 126, depending on when it was filed, CV, et cetera, et cetera, et cetera. And that's the case number. Okay. But I want to go back to the Calderon settlement, because a couple of you here are spouses of U.S. citizens. Gracias. Gracias por recomendarme, te lo agradezco mucho. Martínez Eva, hola, mi tía tiene cáncer y ya tiene cita en Juárez. ¿Le podrían negar la residencia? Ella ya ha hecho el examen médico. Y ¿quién es la residencia? ¿Quién le está pidiendo? ¿Ella está aquí o ahí? Es decir, ¿está recibiendo tratamiento aquí y tiene el perdón y se va ahí? Ovo, any update on the paused lawsuit? I imagine you're talking about DACA. In that case, no. Lo de tu tía Eva Martínez, mira, es que la razón por la cual pregunto lo de dónde está recibiendo tratamiento, porque en teoría no es una negación automática, no es algo que es contagioso, está vacunada, no tiene ya un problema mental donde puede causar daño a otras personas. Sin embargo, ahora sí pueden mirar, por ejemplo, si no tienes recursos económicos como para pagar tus tratamientos médicos, ¿no? Entonces es algo más como económico, tiene ya seguro privado, etc. Es decir, no negarle por razones médicas directas, donde ella tiene una enfermedad contagiosa, sino, oye, por razones médicas vas a tomar ventaja, es lo que dicen, de los recursos públicos de los Estados Unidos, o tienes a tu... tienes seguro médico, recursos económicos, como para comprobar que no vas a tomar ventaja del sistema médico de los Estados Unidos, ¿no? Oh, okay. Is there an update on the pause for the visas? Not yet. Nothing that I know of, at least. Honestly, though, it's so hard to keep up. The other day I was doing a consult with somebody, and from Friday to Monday, there had been an update on the lawsuit for TPS for Honduras, and I was so in the weeds with my habeas, I didn't even know it. My client told me, and I said, what? A decision came out, and I had been so busy looking at other things, so, but I'll write that down as another thing to look into. Make a video about, okay? To confirm where we're at on the litigation. What's next after PIP is approved? I don't know, because I don't know what process you're doing. If you're talking about a military parole in place, and if you're using it for the purpose of like an adjustment, then I don't know if you've done the I-130 yet. If you haven't, then you would do an I-130, I-485 one-step adjustment packet using that approved PIP. Sandra, ¿se puede hacer una cancelación de VAWA que se hizo en junio del 2023 y empezar un proceso consular? Sí, no hay una regla de que no puedes tener pendiente dos cosas a la misma vez. Ahora, si la VAWA se basa en la misma relación que el proceso consular, vas a tener que retirar esa VAWA y proceder con el proceso consular y también explicar, ¿right? Porque te van a hacer preguntas sobre la VAWA, oye, ¿por qué? Es decir, ¿hubo fraude en solicitar la VAWA? ¿Es verdad que sufriste de esta forma, sabes, de violencia doméstica, o te lo estabas inventando para tomar ventaja? Si es basado en la misma relación, la misma persona que te está pidiendo. Si es otra persona completamente, no tienes que retirarlo, puedes simplemente hacer ese proceso. Dream Fuel Studios, caso de amigo esperando la I-130, casi 4 años. Casado con ciudadano en los Estados Unidos, tiene orden de deportación. ¿Cuál es la pregunta? No sé si lo perdí, Dream Fuel, pero ¿cuál es la pregunta? Que si lo debería de hacer, si está tardando mucho. que si debería ir a la cita. Si está casado o casada con ciudadano, acuérdate el proceso Calderón, el que yo acabo de hablar, el acuerdo Calderón, donde automáticamente te anulan la orden de deportación si te mudas a un estado en el noreste, ¿no? Entonces, eso es lo que sugiero. What are my thoughts on TPS for Haitians? I don't know how to answer this. I don't think any of the TPSs necessarily should have been revoked in the manner in which they were. I don't know enough about every single country that's granted TPS to make an educated decision on whether or not it should be, but I do know that they shouldn't have been revoked in the manner in which they were. It should have been a much more comprehensive review. They should have followed the Administrative Procedures Act, which is really the threshold, like the crux of the argument, right? Again, I am not an expert on country conditions in any of these countries that were granted TPS. So I can't really speak to that. I can only speak to the effects and the manner in which TPS is revoked for not just Haitians, but for everyone, right? That I don't agree with. Ok, Eva Martínez y Sandra Justus, las dos estáis haciéndome preguntas sobre como cuestiones médicos, ¿no? Y si eso os va a afectar en el ajuste o en el proceso consular, la residencia, ¿no? Sinceramente, right, te puedo decir como en general lo que están evaluando, pero ya como los detalles específicos de, like, tiene esto, está pidiendo esta ayuda al gobierno, eso a mí no me importa evaluarlo si quieren agendar una consulta y lo puedo evaluar con más detalle. Es simplemente muy difícil responder a preguntas como tan específicas en este foro, ¿vale? En general, mira, el tener cáncer en sí no es un problema por el examen médico, ¿vale? En el ajuste o en el proceso consular porque no es algo contagioso, no es algo que daña a otras personas. Pero ahora, con la evaluación del public charge, el cargo público, sí es verdad que es posible que lo tomen en cuenta para ver si va a ser a burden, financial burden, como un problema económico en el gobierno de los Estados Unidos, como se dice burden en español. ¿No? Entonces, dependiendo de la situación del seguro, cuántos fondos tienen los padres o tu tía, ¿no? Se puede preparar el caso para que sea un caso fuerte, ¿no? Una carga pública o un cargo económico, ¿no? Ya, Cindy, es difícil decirte el costo del ajuste de estatus por la visa T. Ya tienes la visa T aprobada y solo necesitas hacer el ajuste, necesitas algún tipo de perdón. Yo diría que entre 3.500 a 5.000 o por ahí es el rango, pero si quieres hacer la consulta te podemos dar un precio más fijo. Do I think the Supreme Court will give him the green light on revoking TPS for Haitians? Yes. Because that's what they've done with every other TPS. ATM, DACA regresa para primerizos. Todavía no lo sabemos. Se supone que sí, pero no lo sabemos. Rebecca, other suggestions aside from Calderon for spouses with I-130 interviews that have removal orders? I mean, depending on why they have the removal order, right? I've consulted lately with a lot of people. A lot of them are DACA recipients, but not necessarily all of them, that entered the country as children with their parents, and they didn't even know they had a removal order. It was outside of their control. They were 3 years old, 4, 5, 6, 11. And so you reopen that removal and try to dismiss that based on relief available. Now, the issue is that generally we want to have an I-130 approved when you take that route, and that's the difficulty. There is a chance that, yeah, that's the difficulty. You need to go to that interview in order to get the I-130 approved. But you can try. The problem is you generally only have one chance to do that. Hola, abogada, ¿cuánto cree que tarda la FOIA de la CBP? Sí, 1 año y 2 meses. No me sorprende. ¿Se puede demandar al gobierno cuando está tardando tanto para que te den la respuesta y que respondan para la FOIA del CBP? Sin embargo, cuesta dinero, ¿no? Y muchas personas no quieren invertir en una demanda en contra del gobierno, pero la verdad es que eso es el único recurso que hay, o se puede intentar hacer una FOIA de nuevo, a ver si lo procesan más rápido. Evelyn, can we open a deportation removal? So I think you mean a deportation order, and I just talked about that. It depends on what were the terms of the removal order, right? So if the removal order is from when they were a child, they entered with a parent, they didn't really have any control over not appearing, it's an in absentia, then, you know, you have a stronger case than somebody who just was an adult and didn't appear, or did appear but lost, right? In that case, I would suggest doing an I-212 waiver. Yeah, everybody keeps asking about DACA. Nothing yet. I promise if there is something, I know that this is like of great interest to thousands of people. I'll make a video as soon as I hear anything, but no DACA news yet. Oh, thank you, Waterproof. I appreciate that a lot. I pride myself on that. María, la F2A, 6 pasos en mayo 2000, ¿cuándo llegará? Esa categoría no lo sé. No lo sé. Pero yo le estoy diciendo típicamente, a ver, a mis clientes yo le diría ¿tú tienes tu fecha de prioridad, está vigente? No sé, a ver. March, you have to wait visa bulletin. Está diciendo que mínimo como 12 a 18 meses después de que esté vigente tu fecha de prioridad. What's the success rate of filing a bond motion in the Fifth Circuit? 0. The judges are not assuming jurisdiction over these bond. I am assuming the individual entered without inspection. Remember that this pause on bonds and these jurisdictional things are not relevant or don't apply to people who entered with visas, okay? If you entered with a visa, file a bond in the Fifth Circuit or any circuit. Now, you entered without inspection, you're detained, you want to get out and you're in the Fifth Circuit, don't go for bond, go for habeas and request immediate relief from the federal judge. You can have a much stronger chance of success there than filing a bond with an IJ. Okay? Cindy, ya te comenté que son como 3.500 a 5.000, pero depende de la circunstancia, si se necesita algún tipo de perdón, etcétera, ¿vale? Entonces, si quieres, pueden consultar y les puedo dar un precio como más fijo y seguro. So, but I wanna go back because a ver, Bernardo, buenos días, abogada. Mi prima facie por favor vence en marzo 5 en 2 días. Perdón. Tengo que pedir una extensión. I mean, si vence, en teoría no. Se supone que se renueve automáticamente y que lo revisan si no han tomado decisión. Pero si no te lo dan, se puede como escribir y mandar algo para pedirlo. Perdón, es que se me está terminando el live. Ok. En teoría no lo tienes que pedir. ¿Ok? Que si debes esperar un poco más del CBP FOIA. Se puede hacer otra FOIA o se puede demandar al gobierno. No sé qué decirte, right? Como te comenté, es el gobierno, no tienen motivación de cumplir, de responder a esto. Llámanos y hablamos de la opción de demandar, que es lo más seguro. Tardando, lo siento. Cindy, vamos a mirar. ¿Ya se aprobó la visa T? ¿O estás aprobando o estás esperando la aprobación? Ok. Vamos a ver. Processing times. Vamos a ver, ¿ok? Mientras tanto, hola, ¿qué me recomiendas? Yo tuve negación de residencia por VAWA y me ordenaron salir. Si no, se me haría deportación. Creo me metieron miedo y salí. ¿Qué perdón necesito? Enrique, necesitas un perdón por orden de deportación, ¿no? Pero eso depende de quién te va a pedir. Entonces, antes de pedir un perdón, tienes que tener alguna manera de pedir una visa o residencia. Entonces, no sé si tienes esposo, esposa ciudadana, familiar que te va a pedir y luego se tiene que evaluar para ver si calificas para algún tipo de perdón. Te aprobaron la VAWA. Ok, un momento, estoy haciendo dos cosas a la vez. Vamos a ver, la visa T. Están diciendo que está tardando 40 meses. En la página de UCIS lo dice. Itzel Estrada, on average, how long are I-485 interviews taking? Waiting since May 2025. It depends a little bit on the category. Who's petitioning for you or how you're doing your adjustment. Like I just looked up T visa adjustments, which are taking 40 months, right? So if I know a little bit more about your case, maybe I can give you a little bit better of a marriage-based, if it's a US citizen, that's a little, I mean, yeah, about a year, yeah, 12 to 18 months, I would say is kind of the going, is the normal amount of time. Beyond that, you know, once you start to get into the 20-month range, you can start to threaten a mandamus or something like that to compel action. Enrique, ya me estás dando muchos detalles. Te aprobaron la visa, te negaron la residencia, tienes orden de deportación, creo que saliste. No me importa hacer una consulta contigo. Si quieres nos puedes llamar para una consulta, pero es difícil. Sinceramente, es un caso bastante complicado y aquí no lo puedo responder sin como entender mejor los detalles, ¿vale? No es que no quiera, es que simplemente esto requiere una consulta personalizada. Okay, Squishy, do you know if they're doing biometrics if the person filed application before detained? What application, what type of biometrics are you waiting on? Some are routine. What specifically are you waiting for biometrics on? So